The morning the Cedarwood Bluffs HOA sent a compliance officer to my property to photograph my electric fence. I was in the barn doing the morning feeding, and I watched the whole thing from the hay loft window with the specific interest of a man who had been expecting exactly this and had been preparing for it for 6 weeks. The compliance officer was a young man named Todd who drove a white golf cart with the HOA logo on the side and who walked my perimeter fence line with a clipboard and a phone camera with the focused energy of someone who believed he was building a case. He was building a case. I was building a better one. I watched him photograph the fence from 4 angles. I watched him write things on his clipboard. I watched him drive back toward the HOA office. Then I climbed down from the hay loft, finished the feeding, washed my hands at the barn sink, and called my attorney. My name is Harold Briggs. I am 58 years old, retired veterinarian, current operator of a small livestock operation on 11 acres in central Tennessee that I have run since I retired from clinical practice 8 years ago. The property has a farmhouse, a barn, a hay storage structure, and 11 acres of mixed pasture that I use for a small beef cattle herd, 6 head currently, and a flock of 43 sheep. The sheep require predator control. That is the beginning of the story. Coyotes in central Tennessee had been a documented problem in our county for the prior 3 years. The County Extension Service had issued 2 advisories. 3 of my neighbors had lost animals. I had lost 2 sheep in September to what the tracks and the evidence suggested was a single coyote working the property at night. I had consulted with the county extension agent, a woman named Carol Sims, who had 12 years of livestock management experience, and she had recommended electric fencing as the most reliable non-lethal predator deterrent for a sheep operation of my size. I had installed it. The fence was a standard agricultural electric fence, energized by a solar-powered charger rated for the perimeter length, properly grounded, properly marked with warning signs at regular intervals as required by Tennessee Agricultural Code, and installed entirely within my property boundary with the appropriate setback from the road edge. Every component was legal. Every component was documented. The HOA's position was that it was not. The Cedarwood Bluffs HOA covered my neighborhood and several adjacent streets, and my property sat at the development's edge where the residential lots transitioned to the larger agricultural parcels that predated the subdivision by several decades. My 11 acres was zoned agricultural. The HOA's governing documents had been written when the development was built 15 years ago, at which time the agricultural boundary properties had been included in the HOA's geographic coverage area, even though their land use was fundamentally different from the residential lots. That inclusion was the source of the dispute. The HOA's architectural and property standards, written for residential properties, contained a provision that stated all fencing must be of an approved type from a listed selection of materials and styles. The approved list included wood privacy fence, vinyl privacy fence, decorative aluminum, split rail, and chain link with specific height restrictions. Electric fence was not on the list. The HOA board president, a woman named Margaret Holloway, who had been in the position for 3 years and who had a background in residential real estate that gave her strong opinions about property values and community standards, had sent the first letter in October. The letter cited the fencing standards provision and required me to remove the electric fence within 30 days or face daily fines of $100. I had read the letter, and then I had read the HOA's governing documents from the first page to the last. What I found was this. On page 18 of the 24-page governing document, in a section titled Agricultural and Rural Property Provisions that appeared to have been included specifically because the development's edge included properties like mine, there was a clause that read as follows. Properties within the association's geographic boundary that are classified as agricultural under county zoning, and that were in active agricultural use at the time of the association's formation shall be governed by the agricultural standards provisions of this section rather than the residential architectural standards of Section 4. Section 4 was the section with the approved fencing list. The agricultural standards provisions of the page 18 clause were brief. They said that agricultural properties should maintain their structures in good repair, avoid creating nuisances affecting neighboring residential properties, and comply with all applicable county and state agricultural regulations. Electric fencing was not prohibited in the agricultural provisions. Electric fencing was specifically addressed in Tennessee Agricultural Code as a lawful and standard predator control method for livestock operations. I was an agricultural property. My fence was legal under the agricultural provisions. Margaret either had not read page 18 or had read it and decided it did not apply. I wrote back citing page 18, paragraph 2, the Agricultural Standards Provisions Clause, and my property's agricultural zoning classification. I attached a copy of my county zoning certificate and a copy of the Extension Service recommendation for electric fencing. Margaret wrote back saying the board had reviewed my response and maintained that the fencing standards in Section 4 applied to all properties within the HOA's geographic boundary, regardless of zoning. I forwarded everything to my attorney, a man named Dennis Holt, who had handled my property matters for 6 years and who read the governing documents over a weekend and called me Monday morning. He said, "She is wrong." I said, "I know." He said, "The agricultural provisions clause is clear. It creates a separate governance track for agricultural properties. The board's position that Section 4 applies regardless of zoning is not supported by the document." I said, "That was my reading." He said, "I want to send a letter." I said, "I want to do something first." He said, "Tell me." I said, "I want to document the predator situation comprehensively before we respond to the legal argument. If this goes to court, I want the record to show not just that my fence is legal, but why it is necessary." Dennis said, "You are thinking about the equitable argument." I said, "I am thinking about the full case. The legal argument is strong. The equitable argument makes it complete." He said, "What documentation are you building?" I told him. Over the following 6 weeks, while Margaret sent 3 more letters and Todd drove his golf cart around my fence line, I built a documentation file that covered the following: the County Extension Service's Predator Advisory Bulletins for the prior 3 years, Carol Sims' written recommendation letter specifically advising electric fencing for my operation, a veterinary assessment of the 2 sheep I had lost in September, documenting coyote predation with clinical specificity that only a retired veterinarian with 30 years of large animal practice could provide, photographs and track measurements from the September incidents, a documented survey of predator incidents on neighboring livestock properties in the county, compiled from county extension records and published agricultural reports, the electric fence installation documentation, including the permit filing, the energizer specifications, the grounding documentation, and the warning sign placement photographs, the Tennessee Agricultural Code sections specifically authorizing electric fencing for livestock predator control, and the page 18 Agricultural Provisions clause highlighted and annotated. I also documented something that I had not initially planned to document, but that became relevant when Margaret's 4th letter escalated to a threat of legal action. The 4th letter said the board had engaged legal counsel and that if the fence was not removed within 14 days, a civil complaint would be filed seeking injunctive relief and accumulated fines. I drove slowly through the Cedarwood Bluffs development that weekend, not intrusively, just driving, looking at the fencing along the residential lots. I found 3 residential properties with fencing that was not on the approved list. 2 had wooden privacy fences that were the correct material but exceeded the approved height by 6 inches. One had a decorative fence that used a material not on the approved list. None of these had received compliance letters. I confirmed this through a public records request to the HOA's own compliance log, which was a document that Tennessee HOA law required to be maintained and made available to members. The compliance log showed no violations issued for any of the 3 properties I had identified. It showed 1 violation in the prior 12 months other than mine. Selective enforcement. Dennis said, "That is significant." I said, "Selective enforcement against the only agricultural property in the HOA." He said, "While 3 residential properties with comparable or identical violations received no notice." I said, "Documented from the HOA's own compliance log." Dennis said, "Harold, I was already confident in the legal argument. The selective enforcement documentation changes the character of the case." I said, "How?" He said, "A court looking at selective enforcement against a protected class of property, agricultural versus residential, combined with a governing document that specifically provides separate treatment for agricultural properties, is looking at a pattern of bad faith enforcement. That affects the damages analysis significantly." I said, "What damages?" He said, "Attorney's fees. Under Tennessee HOA law, a prevailing party in an HOA enforcement dispute may recover attorney's fees if the court finds the enforcement action was brought in bad faith or without reasonable basis." I said, "You think we can get fees?" He said, "With selective enforcement documentation and the page 18 argument, yes." I said, "Then we are ready." Dennis sent a formal response letter the following Monday, 14 days before Margaret's deadline. The letter was 11 pages. It cited the Agricultural Provisions Clause with full paragraph citation. It attached my county zoning certificate. It cited the Tennessee Agricultural Code authorization for electric fencing. It attached Carol Sims' recommendation letter. It attached the predator incident documentation. Then it addressed the selective enforcement. It noted the 3 residential properties with compliance violations that had not been cited, identified by address, with the violations described. It cited the HOA's own compliance log showing no action on those properties. It noted that the only compliance action in the prior 12 months had been against the HOA's sole agricultural property. It concluded by stating that if the HOA filed a civil complaint seeking injunctive relief, the response would include a counterclaim for declaratory judgment confirming agricultural exemption, a counterclaim for selective enforcement, and a motion for attorney's fees under the applicable Tennessee statute. Margaret received the letter on a Wednesday. She did not respond within the 14-day deadline she had set. She did not respond at all. Instead, on the 15th day, she filed the civil complaint. I read the complaint when Dennis forwarded it to me. It cited Section 4's fencing standards. It sought an injunction requiring removal of the electric fence. It sought accumulated fines of $12,000 for the 120 days since the first letter. It did not mention page 18. It did not mention the Agricultural Provisions Clause. It did not mention the selective enforcement. It was as though Dennis's letter had not been received. Dennis said, "She filed anyway." I said, "She filed anyway." He said, "Without addressing any of the arguments we raised." I said, "Yes." He said, "Harold, that is either a very confident position or a very poorly considered one." I said, "What do you think it is?" He said, "I have read their complaint. They did not cite the governing documents in full. They cited Section 4. They did not acknowledge Section 18. I said, "Can they win without acknowledging Section 18? He said, "No, a court reads the full document. Section 18 will be before the judge regardless of whether the HOA's complaint cites it." I said, "Then it is a poorly considered position." He said, "File the response today." The response was filed that afternoon. 31 pages. Counterclaims for declaratory judgment, selective enforcement, and attorney's fees. Full documentation attached. The hearing was scheduled 6 weeks out. That was the end of part 1. Todd had his photographs. Margaret had her complaint. And I had 31 pages, 11 years of veterinary documentation habits, 6 weeks of evidence building, and a page 18 that the HOA had decided to pretend did not exist. Part 2 is where the judge read the full document. The hearing was before Judge Caroline Marsh in the Williamson County Circuit Court on a Thursday morning in February. I want to describe Judge Marsh before I describe what happened in the hearing, because her approach to the case reflected something about how courts handle HOA disputes that I had not fully anticipated and that Dennis had not fully predicted either. Judge Marsh was 62 years old, had been on the bench for 14 years, and had grown up on a farm in Robertson County before her legal career. Dennis mentioned this to me before the hearing as context, not as a prediction, because judges do not decide cases based on personal background, and Dennis knew that. But context is context. She had read the full case file before the hearing, both parties' submissions, the governing documents in their entirety, the documentation attachments. Dennis could tell she had read everything because when she entered the courtroom, she had a copy of the governing documents with visible tab markers, and she asked a preliminary question before either party had said a word. She said, "Counsel for the plaintiff, I have reviewed the governing documents submitted as Exhibit A. I want to confirm that this is the complete and unaltered governing document for the Cedarwood Bluffs HOA." Margaret's attorney, a man named Philip Cross, who I recognized from descriptions in previous matters as someone who was competent but who had apparently not fully advised Margaret on the weakness of her position, said yes, the exhibit was the complete document. Judge Marsh said, including the provisions on page 18. Philip Cross said, "Yes, Your Honor." She said, "I want to start there." Philip Cross said, "Your Honor, the plaintiff's position is that Section 4, the Architectural and Property Standards, applies to all properties within the HOA's geographic boundary." Judge Marsh said, "I understand the plaintiff's position. I have read it. I am asking about page 18. She opened the document to her tab marker. She read the Agricultural Provisions Clause aloud. Then she looked at Philip Cross. She said, "Counsel, the defendant's property is zoned agricultural and was in active agricultural use at the time of the association's formation. That is documented in the defendant's exhibits and not disputed in the plaintiff's complaint. Based on the language I just read, does Section 4 apply to this property?" Philip Cross said, "The plaintiff's position is that the Agricultural Provisions Clause does not supersede the general fencing standards because the fencing standards represent community-wide consistency requirements that apply regardless of use." Judge Marsh said, "Where in the governing documents does it say that?" Philip Cross said, "It is implicit in the overall framework of the document." Judge Marsh said, "I do not decide cases on what is implicit. I decide them on what the document says. The document says agricultural properties in active use at formation are governed by the agricultural standards provisions rather than Section 4. Where is the ambiguity?" Philip Cross said, "The plaintiff reads the document differently." Judge Marsh said, "Counsel, I have been reading legal documents for 38 years. This document is not ambiguous on this point. The agricultural exemption is clear." She turned to Dennis. She said, "Counsel for the defendant, let us hear the agricultural standards compliance argument." Dennis presented the case in 40 minutes. He covered the agricultural zoning classification, the active agricultural use documentation, the Extension Service Predator Advisory and Carol Sims' recommendation, the predator incidents and the veterinary documentation, the Tennessee Agricultural Code authorization for electric fencing, the fence installation compliance with all applicable regulations, and the selective enforcement documentation, which he presented last with the compliance log extracted and the 3 uncited residential violations identified. Judge Marsh listened to all of it without interrupting. When Dennis finished, she turned back to Philip Cross. She said, "Counsel, I want to address the selective enforcement evidence. The defendant has produced the HOA's own compliance log showing 3 residential properties with compliance violations that received no notice during the same period the defendant was cited. Do you dispute the accuracy of the compliance log?" Philip Cross said, "The plaintiff does not dispute the log's accuracy. The plaintiff's position is that enforcement priorities are within the board's discretion." Judge Marsh said, "Enforcement priorities are within the board's discretion when the enforcement action is otherwise valid. When the underlying enforcement action is based on a misapplication of the governing documents, selective enforcement becomes relevant to the bad faith analysis." She said, "Let me tell you what I am looking at, counsel." She said, "I am looking at a governing document that explicitly exempts agricultural properties from the fencing standards being applied. I am looking at an agricultural property owner who cited that exemption in response to the first violation letter. I am looking at subsequent letters from the plaintiff that did not address the exemption. I am looking at a civil complaint that does not cite the exemption. And I am looking at a compliance log showing that the plaintiff's board enforced a fencing standard against an exempt agricultural property while not enforcing the same standard against non-exempt residential properties with comparable violations." Philip Cross said, "Your Honor, the plaintiff was not aware that the agricultural exemption applied." Judge Marsh said, "Counsel, the defendant cited page 18 with full paragraph citation in a letter to the plaintiff's board 6 weeks before this complaint was filed. Are you telling me the board was not aware?" Philip Cross said, "The board reviewed the defendant's letter and disagreed with the interpretation." Judge Marsh said, "On what basis?" Philip Cross said, "The board's position was that Section 4 applied regardless." Judge Marsh said, "Despite the defendant's citation of a provision that directly contradicts that position." Philip Cross said, "Yes." Judge Marsh said, "Without obtaining a legal opinion on whether the defendant's interpretation was correct." Philip Cross was quiet for a moment. He said, "The board consulted with me." Judge Marsh said, "And you advised them to proceed?" Philip Cross said, "I advised them that their position was supportable." Judge Marsh looked at him for a long moment. Then she said, "Let us take 15 minutes." The recess lasted 22 minutes. When Judge Marsh returned, she did not ask further questions. She said she was prepared to rule from the bench. She said, "The governing documents of the Cedarwood Bluffs HOA contain a clear and unambiguous agricultural provisions clause that creates a separate governance track for properties that are agriculturally zoned and were in active agricultural use at the time of the association's formation. The defendant's property meets both criteria and is therefore governed by the agricultural standards provisions, not by the Section 4 fencing standards on which the plaintiff's complaint is based." She said, "The plaintiff's complaint is dismissed in its entirety. The accumulated fines of $12,000 are voided. The requested injunction is denied." Philip Cross said, "Your Honor." She said, "I am not finished, counsel." She said, "The counterclaims for declaratory judgment are granted. The court finds that the defendant's electric fence is lawful under the agricultural standards provisions and the applicable Tennessee Agricultural Code, and that the HOA may not apply the Section 4 fencing standards to this property." She said, on the counterclaim for selective enforcement, the court finds that the plaintiff enforced its fencing standards against an agriculturally exempt property while declining to enforce the same standards against non-exempt residential properties with comparable violations. This constitutes disparate treatment. She said, on the counterclaim for attorney's fees, The court finds that the plaintiff's enforcement action was brought without reasonable basis. The defendant cited the applicable governing document exemption in correspondence 6 weeks before this complaint was filed. The plaintiff's board proceeded with litigation without addressing the cited exemption and without obtaining a comprehensive legal opinion on its applicability. The defendant's attorney's fees in this matter are awarded. Philip Cross said, "Your Honor, the attorney's fees award," she said, is supported by the Tennessee HOA statute authorizing fee awards in enforcement actions brought without reasonable basis. Your client cited a provision. They received a letter citing the exemption. They chose not to engage with it. That is the definition of proceeding without reasonable basis. Dennis's fees were calculated at $18,400, covering the full period from the first response letter through the hearing date. The HOA was ordered to pay them within 30 days. Philip Cross asked for a stay pending appeal. Judge Marsh said, "Counsel, do you have a basis for appeal?" Philip Cross said, "The interpretation of the governing documents." Judge Marsh said, "I have interpreted unambiguous language. An appeal of an unambiguous interpretation is unlikely to succeed. The stay is denied." The hearing ended at 11:47. Dennis and I walked out of the courthouse into a cold February morning and stood on the steps for a moment. Dennis said, "Agricultural Provisions Clause." I said, "Page 18. He said she had read it before she walked in. I said she grew up on a farm. He said that is not why she ruled the way she did. I said no, she ruled the way she did because the document says what it says. He said the fees. I said $18,400. He said Margaret proceeded without engaging with page 18. I said she had the letter, she had the citation, she chose not to engage. Dennis said that is the definition of bringing an action without reasonable basis. I said Judge Marsh's words. He said they were accurate. Margaret Holloway called me the afternoon of the hearing. Not through Philip Cross, directly. She said, "Mr. Briggs." I said, "Ms. Holloway." She said, "I want to tell you that I read your response letter when it arrived, the one with the page 18 citation." I said, "I assumed so." She said, "I took it to Philip, and he said our position was supportable." I said it was not. She said, "I know that now." She said, "The board is going to have to assess the membership for the attorney's fees award." I said, "I am aware of how HOA assessments work." She said, $18,400 across the membership. I said, "Ms. Holloway, the assessment is the consequence of proceeding with an enforcement action that the defendant had specifically cited as legally unsound." She said, "I know." She said, "Was there any way this could have been resolved without court?" I said, "Yes. When you received my letter citing page 18, you could have taken it to the full board with a recommendation to withdraw the compliance letters and conduct a proper review of whether the agricultural exemption applied." She said, "Philip said our position was supportable." I said, "You should have gotten a second opinion." She was quiet for a moment. Then she said, "The fence, it stays." I said, "The fence stays. It is lawful. It is necessary. The court has confirmed both." She said, "The coyotes," I said, "are still active in the county." She said, "And you have sheep." I said, 43 of them." She said, "The fence is doing its job." I said, "Since installation, no losses." She said, "I am sorry, Mr. Briggs." I said, "I appreciate that." The assessment went out to Cedarwood Bluffs members the following month. $18,400 divided across 114 households came to approximately $161 per household. Not an enormous amount per person. Not a nothing amount per person. $161 per household because the board president had read a letter citing page 18 of the governing documents, consulted an attorney who said the position was supportable, and filed a civil complaint without engaging with the cited exemption. The HOA's annual meeting was held 3 months after the hearing. Margaret did not run for re-election. The new board president, a man named Howard Tillman, who had been a regular board member for 2 years and who called me the week after his election to introduce himself, said he had reviewed the full governing documents and intended to ensure that enforcement actions were reviewed for compliance with all relevant provisions before being issued. I told him I appreciated that. He said, "The Agricultural Properties Clause." I said, "Page 18. He said, "I have tabbed it." I said, "Good." He said, "Mr. Briggs, would you be willing to come to the next board meeting and talk about the agricultural properties in the HOA's coverage area? There are 3 others besides yours." I said I would be glad to. I attended the meeting. I brought Carol Sims from the Extension Service. We spent 45 minutes talking about the 3 agricultural properties, their zoning, their current use, and the specific provisions of the governing documents that applied to them. 2 of the other agricultural property owners were in attendance. None of them had been aware that page 18 existed. I told them about it. I told them to read it. I told them to keep it in a folder. One of them said, "Is this because of the fence case?" I said, "This is because of page 18. He said, "Same thing." I said, "Not quite. The fence case was about enforcement. Page 18 is about understanding what you own and what governs it." He said, "And if the HOA comes after one of us?" I said, "Read your document, all of it, not just the section they cite, all of it." He said, "That is good advice." I said, "It is the only advice that matters." The electric fence is still standing. It has been standing for 14 months since installation. No livestock losses since installation. The energizer runs on solar, and the indicator light is green every morning when I check it during the feeding. Green means charged. Green means working. Green means the coyotes are on their side of the wire and my sheep are on mine. Here is what I will leave you with. Margaret Holloway was not a dishonest person. She was a person who read the section that supported her position and did not read the section that contradicted it. She received a letter citing the contradictory section with full paragraph citation. She took it to an attorney who told her the position was supportable. She proceeded. The judge read the full document. The judge found the agricultural exemption clear and unambiguous. $18,400 in attorney's fees followed from the decision not to engage with a cited provision. $161 per household. Because nobody read page 18. Read your documents. Every page. Not just the section that supports what you want to do. Every page. The provision that protects you might be on page 18. The provision that defeats someone else's case against you might be on page 9. The provision that changes everything might be in a section that nobody bothered to tab. Tab it. Read it. Keep it. And when someone sends you a letter citing a provision you had not considered, engage with that provision before you file a civil complaint. Philip Cross should have told Margaret that. He did not. The judge told her instead. It cost $161 per household to hear it. Drop your thoughts below. If an HOA has enforced a rule against you that you later discovered did not apply to your property, tell me about it. And if you have an HOA governing document you have not read in full, read it this weekend. Start on page 1. Do not stop until you reach the last page. Page 18 might be waiting for you. End of part 2, approximately 7,000 words. Thumbnail text. She ignored page 18. The judge made her entire HOA pay for it.